women need to be submissive to men in all situations. If not, they need to be punished. He actually had discussions with my daughters about how he doesn't believe women should be allowed to vote.
Parties have not been able to agree on any parenting time within the past 3 months. And at this point, defendant is refusing to allow plaintiff to see the child.
The child is being used as a tool to collect evidence for this case.
Michelle Schaefer versus James Schaefer.
Court will note the appearance of Mr. Sullivan on behalf of the defendant. This matter is before the court on the defendant's motion for parenting time. Mr. Sullivan.
Thank you, Your Honor. The motion is fairly straightforward and presents the fact and law upon which it's based. The essence of it is that there is a order in place that does not provide a specific parenting time schedule for the defendant, and the decisions as to when parenting time will occur therefore are left to the voice of the person who has primary physical custody, which is Ms. Schaefer. We did receive what I believe Ms. Schaefer presents as her answer to the motion over the weekend. It was in the mail that came in over the weekend. I shared it with my client. My client vehemently disagrees with most of what's in there, but I did want to point out one piece of information that is in Exhibit A, and it's a text message from Ms. Schaefer to Mr. Schaefer, in which she writes, "If you ever refer to me as not parenting my 2-year-old correctly again, I will discontinue visits because of your rude comments." That really kind of illustrates why we're here today. That's not the type of a parameter that should exist when awarding parenting time to a parent. As the court knows, the law is based on the presumption that parenting time with both parents is in the best interest of the child in a meaningful way and with significant duration. So that's why we're here, Judge. We would expect to have a hearing on this issue and let the court make a decision about the degree to which the schedule should be defined.
Okay, thank you. Ms. Schaefer, what's your response?
Am I unmuted?
Yes.
Okay. Yeah, I looked over the motion that he presented, and I did want to state for the court record that I did receive the motion in the mail last Saturday. I have been trying to contact Mr. Sullivan because today I have 7 appointments today, and I'm in my car. I asked for him to adjourn so that I would have more time to prepare. And obviously he didn't get back to me. So I am just going to go at this. I have I have consulted over the original order. I've consulted the caseworker Samantha Farrakasi and Margot Cummings and Highfields that help integrate me. And because of the nature of our situation and me having to supervise parenting times at times, it is very uncomfortable. And so there are issues. And I did submit that to the court, that exhibit, because it was just, it was bizarre. And there were words exchanged without children present in the house. And I was frustrated because I'm trying to obey court orders, uphold court orders, but yet give him room to be with the kids and be flexible in things. And I was advised by my legal advisors that because of the order, the way it's written, that I have physical and sole custody, or physical and legal custody of the kids. If we cannot come to an agreement, or there are escalations that have happened at parenting time, that I have the right to discontinue parenting time for a time if we cannot agree. And so I did, I'm trying to find that. I was upset because he did come down pretty hard on me that I let my children rule over me, and it was just very uncalled for at that time. So I think that you've probably read through the affidavit that I submitted, and at this time, I do think that each parent should have a right to the children according to what the law states, but I also do think that it is in the best interest of the children to be protected physically, mentally, and emotionally. And the things that are said to the children at parenting time lead my older children are disturbing. And I think that you've read through the affidavit. I'm very concerned. I have lots of concerns, obviously, that we don't have to go over today. But one of my main obvious concerns is that this didn't just happen yesterday. The reason why we were here in court to begin with, the children's mental and emotional stability and physical stability is one of my main concerns in life. That's why I've been a stay-at-home mom for almost 25 years. I did want to what is disturbing is his comments about women and the religious factor that factors into our case. He's mentioning to the girls in front of the boys, which is a concern for all of us, that, you know, women need to be submissive to men in all situations. If not, they need to be punished. He actually had discussions with my daughters about how he doesn't believe women should be allowed to vote. He did this in front of everyone, even the small children could hear. And so it's things like this that really mess with people's heads. They mess with the children. Children don't know how to process this. It's detrimental. So I do have concerns. I have issues.
Okay. That's understandable, and we'll address those issues at a hearing.
Oh,
What the court's going to do is the court is going to refer this to referee for a hearing on parenting time, and you'll be contacted by the referee probably within a couple weeks, a week and a half or so, to set up that particular hearing, and then you'll have an opportunity to present all of your evidence at that time. So that's what we'll do, and we'll get that prepared and out, and then you'll be contacted by the referee. So free to go today. Have a good day.
thank you,
Thank
Your
you,
Honor.
Andrea Roche versus Kevin Gleason.
Court will note the appearance of Mr. Schaefer on behalf of plaintiff, Ms. Bowen on behalf of defendant. The matters before the court on the plaintiff's motion to show cause. Mr. Schaefer.
Please the court, Your Honor. Back on July 1 of 24, there was a temporary order entered that kind of set forth about 4 different things that need to be done on a temporary basis in an effort to bring some resolution to this. And we have set forth in our petition that they have not been complied with. The first one is that the cameras were to be taken down and no recordings taken place. The recordings continue, still up. The answer indicates, well, they weren't facing, but they are still running. And in fact, he advised the counselor in September that they are still going on. That's problematical. Number 2 is that it was set up for some one-on-one with the father and the daughter. That has taken place very minimally, and the same problem continues on with the anxiety that's going on in the home as it relates to the daughter. Number 3, counseling has not gone as anticipated, at least. There has been a couple of, since we have filed this petition, and the report that there's still great anxiety going on, and it took 2 or 3 months for that to get. And number 4, the living room window was to be closed at night, and the only answer we got to that in the pleading, the daughter can close, not what the order indicates. The long and the short of this, Your Honor, is that the daughter is going through a lot of anxiety that is represented by the counseling problem. She is having difficulty in the home of her father. She would like to have a relationship with the father, but outside of that home because of the conflict with the stepmother and the way that the father is dealing with that conflict. And what is really coming up is that in Christmas, there's an extended period of time set forth in the order that the daughter does not want to emotionally wise deal with because it is so stressful to her. We're asking for relief at this point in time that until the counseling seriously gets addressed and some sort of relationship take place, that the parenting time be suspended until that happens. That's our request, Your Honor.
Thank you. Ms. Bowen?
Yes, Your Honor, we rely on our pleadings, specifically regarding what Mr. Schaefer just detailed. There is a camera not facing the child's bedroom that's still that is active, and that's I mean, frankly, kind of obvious the reasons why at this point, because the child is being used as a tool to collect evidence for this case, and Mr. Gleason doesn't feel comfortable with allegations the child may make up if that camera doesn't continue to go in the home. But I would note that it's not facing her bedroom. It's not a privacy concern or anything like that. And it's also with the attached exhibits here, it's further amplified by the fact that the child's taking selfie, trying to appear as if she's taking selfies to get a camera in the background, again, to collect evidence for this court, not appropriate. Regarding the part of the temporary agreement that Saturdays would be spent more of an attempt between one-on-one time with just dad and the child, that absolutely has been happening. If the stepmom isn't at work, she stays away to not just comply with this order, but also with the child's wishes of more one-on-one time. Regarding the therapy, as this court knows, it can take longer than we would like to get an initial session with the therapy. Mr. Gleason, within a few weeks after the temporary order, was contacting the child's counselor's office diligently, could not get in a first session until the beginning of October here. So there's only one session, minimally 2 sessions under Mr. Gleason's and the child's belt now. We would request that the temporary order continue as is. This is just a kind of Hail Mary to circumvent the temporary order and the evidentiary proceedings that are currently taking place in front of referee right now. The issues that are mentioned here, the counseling is going on, I mean, the child is 13. She can close a window at night if she wants. These are all very, I mean, not to minimize the child's feelings, but these are all very small things where a request for relief of suspended parenting time is absolutely not appropriate. We're not talking about abuse, neglect. We're not talking about reunification proceedings here. We're talking about a evidentiary hearing that has already partially taken place. We entered a temporary agreement to allow this counseling to attempt to heal whatever is broken in this relationship, and other smaller things in place in the interim for parenting time to continue, and that is what has been happening. There has not been violations. So we would request the court to deny plaintiff's request for relief for suspended parenting time here. Minimally, if we have to go to an evidentiary hearing, that would unfortunately be the appropriate alternative.
Okay, thank you. Well, in this particular matter, the court first will say the court will order that the parties comply with all provisions of the court order. Court notes in reviewing the defendant's answer that the defendant had stated in the answer, well, the camera is not facing Ava's room. Well, I will remind you, the order states that the camera facing the bedroom of Ava at the defendant's father's house shall be taken down. It didn't say redirected. It didn't say not. It says taken down. That's what the court orders, and that's what the court will continue to order. If in fact he doesn't remove that, then the court will consider the alternative to suspend parenting time because he's not complying with the order. Court further stated in there that the window will be closed. It doesn't state that the child has to do it. Doesn't state that some other third party has to do it. It's his house. He's responsible for doing that. So he's got to make sure that that's taken care of. So the order and the other parties, any other third parties are not part of this action, nor does the court have jurisdiction over them. So court will enforce it only against the party that the court has jurisdiction. So he needs to comply with the order or be found in contempt of court. So, Mr. Schaefer, you can simply reiterate what I've stated today, and that will be the order of the court.
Your Honor, thank you, and I will do so. Would the court consider lessening the upcoming Christmas extended
No.
period of time?
I will not at this time, no.
Okay, thank you.
Thank you. You're free to go. Have a good day.
Thank you, you as well.
Devin Sanders versus Melanie Sanders.
This matter is before the court on the plaintiff's motion to modify custody and parenting time. Mr. Todd.
Thank you, Your Honor. Your Honor, the most recent order is from July, but since that point, there have been a substantial change in circumstances. There is a pending open CPS investigation against the defendant. The minor child in this particular case has special needs, and the child has not been attending counseling. The parties have not been able to agree on any parenting time within the past 3 months. And at this point, defendant is refusing to allow plaintiff to see the child. We did outline our best interest factors within the motion. However, I believe the court would need an evidentiary hearing anyway. So we are respectfully requesting that the court hold an evidentiary hearing in relation to custody and parenting time.
Okay. Ms. Sanders, what's your response? And you're muted, ma'am.
Hi, sorry. So the response that I have for this is Devin and I had the agreement that he could call anytime to set up a visitation. He saw Tyrese a couple months ago. And after that, Tyrese ended up with COVID. So I said, we're going to put a hold till everybody's no longer sick. Devin has only called Tyrese one time to talk to him for maybe 10 minutes throughout all of this time. I have, made multiple calls to Devin on Tyrese's behalf for Tyrese to talk to his father. Devin does not answer. Tyrese leaves messages. It's not just so the CPS case that happened is because I lost my fiance to a motorcycle accident. His sisters came in and called CPS because they thought that there was a child unattended in the house. There was no child. It was my 16-year-old nephew who was in the house dog sitting, while my son, the child that would have possibly have been in there, was at the babysitter's. That case is basically resolved. When it comes to parenting time, it is up to our discretion. I've tried numerous times to get Tyrese over there. Usually they're sick or there's something going on. He was just over there this Halloween and the weekend before that, or the weekend before that. So he has seen his father. He has gone over there. We have gone to therapy. Just this last week, we ended up getting back into that. I had to move out of my house. We had all sorts of different family issues that came up, which is no excuse. However, it took me a second to bounce back. And at this point in time, Devin took that stand for me getting back on my feet to make a case. And instead of, Devin asked, a weekend, and we had plans. Tyrese had plans for a play date that weekend. So I told him no, but we could try again the next weekend. And they get upset every time that they don't get their way, even though I ask for a phone call. Just call me, please. And he still does not. I sent him a picture this morning. Today was his first day officially at school. I don't get response from Devin's. This last weekend on Wednesday, when he went to Dad's house, we were supposed to meet in Parma at noon. Devin overslept his 10 o'clock alarm and then used every reason for why he could not pick up Tyrese until after he picked up all the other children at 6 o'clock to come get Tyrese.
Okay. Well, it sounds like there's a lot of issues here, and I'm not going to resolve those today. what we'll state is, in this particular matter, we're going to need to wait CPS investigation. I would state if in fact the CPS does not substantiate the case in this matter, the court does not believe that there's proper cause or change in circumstances sufficient to meet Barca threshold, but the court will allow the plaintiff to proceed on the motion for parenting time if in fact, again, and in fact, if the CPS substantiates, then that issue could go to the referee as well, and send the matters to the referee for evidentiary hearing. So with that, we'll refer the matter, and I'll make that clarification in the referral, awaiting the CPS results on that referral. Okay, you
Do
ready to go? Have a good day.
you need me to prepare anything?
No, we'll get that.
Okay, thank you, Your Honor.
Okay, thank you. This matter is before the court on defendant's notice for entry of order regarding parenting time. Ms. Reed, are you objecting to the order?
We are, Your Honor. I have not been able to talk to my client since the hearing. However, it's my understanding of the agreement is that the grandparenting time would terminate upon mom's release from prison, since we are essentially adopting the temporary order that the court had ordered previously. So we're requesting that that language be added, or language be added that if we're not going to terminate the grandparenting time when mom's released, since there might be like a reintegration period, that grandparenting time coincide with mom's weekend parenting time. Because the effect of the order as written right now is upon release, mom would be expanding her parenting time to every weekend, and the grandparents would be getting every weekend. And that's our concern, and that's not what my client agreed to.
Okay, Mr. Bartel, what's your response?
Your Honor, we put on the record after there was negotiations, I put in our proposed order exactly what we had agreed upon. I guess if the court wants to go back and listen to that, that is exactly what was put on the record. What Ms. Reed is suggesting is now going into a different area that we had never discussed or agreed upon with regards to this. So I just put everything that we had agreed upon, and I'd ask that the order be entered. If the time comes that Ms. Morgan is released from prison, then I guess we can address it at that time. And I say that because unfortunately, plaintiff in this matter, at least from my perspective, for whatever it's worth, is he's played games and likes to do these little things. And as Ms. Reed has even indicated, she hasn't even talked to her client since that hearing. She can't even get a hold of her client, yet they're objecting. They did not file a written objection and a proposed alternate order. So I'd ask that our order be entered.
Well, to I guess to eliminate and address Ms. Reed, obviously there wouldn't be the intent that there was no intent, I think, for, let's say, the grandparents to have alternating weekends and then mom having alternating weekends when she got out of prison. Perhaps the best thing to do is maybe modify the order that states that in fact the interveners would have the parenting time, those alternating weekends, until such time as her parenting time resumed. That way, if there's a delay after she gets out, then it doesn't mean it doesn't end at the time that she gets out of prison, but at the time it would simply, their parenting time would end at the time that she commenced receiving her parenting time as well. So I guess I'd ask Mr. Bartel if you would modify the order to include that.
Okay.
And resubmit it under 7 days, then we can get that entered.
Okay, I will. Thank you.
Thank you.
All right, thank you.
Graham versus Sean Graham.
This matter is before the court on the plaintiff's motion to set aside referee order in this case. Ms. Sutherland, you can
Yes.
proceed. Court has reviewed the file, and I note that this principally pertains to the Kia vehicle. Is that correct?
Yes, Your Honor.
Okay. And court notes, I have reviewed the defendant's response as well. And he had stated he had surrendered that vehicle, and it shows, the paperwork shows it was surrendered on December 21, 2023, prior to the judgment being entered on 1/19/2024, he does remain responsible solely for that debt in this matter. So I guess what are you asking for?
I'm asking for my name to be removed from the liability on the Kia because I am still held responsible for it also. And it's holding my credit. And I'm no longer able to get a car loan, a home loan, or anything like that. And that's hindering my ability to get a new vehicle. My vehicle that I have now is damaged and it's not safe for my daughter to ride in. And I've asked him to remove it out of my name. That way I can get a new vehicle, but he refuses to do so. And he was supposed to remove my name from it also.
Okay, yeah, it said that he was to refinance it within 90 days of the judgment, but again, it was surrendered prior to that time. Sir, are you able to do anything that would in fact remove the matter from Ms. Sutherland's name?
I have talked with the bank personally and the collections for the bank, and the only thing that would be possible to remove her name is to refinance it. However, I don't have the means to get a $36,000 loan to refinance it, and no place will give me a loan for that much money to refinance in my name only. My credit took a hit from all this as well, so I'm having just as hard as the time as she is to get a loan.
Understand. But in fact, you're responsible for that.
Yeah, I've been responsible ever since it's surrendered. I've made payments on time. I've set up payments with Advia Credit and Collections Agency. I haven't missed a payment. She's not had to do anything with the car itself. So I've been taking care of it ever since it's been surrendered.
Okay. Well, ma'am, in this particular matter, because obviously because of the timing, it was surrendered prior to the judgment, there's not a lot the court can do in this matter other than to reaffirm that, in fact, he is solely responsible for that indebtedness and that you're not. So perhaps the best thing that the court can do would simply state in this matter that reaffirm that in fact he's solely responsible on that, that he'll hold you harmless from any obligation, and that you are not responsible for that. Maybe if you did that and you had an order to that effect, maybe whoever you're dealing with would in fact recognize that and recognize that you're not liable. But I'll tell you, it's a little bit difficult because the court, even though you have that in your judgment, the court cannot intercede in obligations between parties and their particular creditor. So there's nothing that we can do with regard to the creditor to have that removed from your name. So I don't know if you want to try that, if you want to do an order to that effect, saying that he's solely responsible for that obligation and that, that in fact you are not. Perhaps that would assist you in going forward in this matter.
I have talked to my creditor on that and who I was going through to get the car loan. And they said, since it is showing on my credit as delinquent and it is derogatory, that they are still holding me accountable for the loan. And they will continue to look at it until it is off my credit, which if he continues to make the payments that he's making, it'll take 3 to 4 years for it to come off my credit. And I can't wait that long to get another vehicle, unfortunately. And they will not, because I've shown them the divorce papers and I've shown them that I'm not supposed to be held liable for it. But since it's still in my name, I am still liable if he does miss a payment, which also has my Advia bank account frozen. It has been frozen since December 2022 or December 22nd when he surrendered the car. It froze my bank account, froze all my assets with Advia.
Well, what are we talking assets wise?
They were nice enough to allow me to take out my paycheck, but there was money in there.
Okay, I'm asking you what amount. I don't want a dissertation on what happened.
There is currently no money in the account.
Then
They have-
they're not holding any of your money then, correct?
No, because they have used it to put towards the loan and the car loan.
Okay,
They-
how
if
much
I-
was it, how much was in there that was utilized to go towards the car loan?
Roughly $500.
Okay. Well, get the documentation for that from Advia to show what was in there and show what they did. What the court can do is order that he would reimburse you for whatever it was that they took to go towards that car loan. And we can order that, but really, that's the extent of what the court can do at this point.
Also, if I do put anything in there, they,
Okay, I'm just saying that you're not gonna be able to bank at Advia then at this point, because again, they'll take anything as it relates to that debt.
yes, and we also have a joint loan through Advia, so I have to continue making payments on that loan. So I do have to still put money in there. So if any time I put money in there and he's late on his payment, they put it towards the car.
Well, what you're gonna have to do is, you're gonna have to work with them and what I would do is not put money in there, but write, if you would, is get a different account, write whatever it is that you owe on that joint loan, write that amount and pay, like make a payment to Advia on that, but don't have anything go through an account that they could possibly execute against.
Yes, Your Honor.
So find out what, get your paperwork to show what you had that they seized to go towards that debt. And the court will order that he reimburse you that amount. And we'll give him whatever you can get the paperwork and provide that to him. And the court would order and I'd give him 90 days to reimburse you for whatever that amount was.
So I'm not getting a vehicle and this is causing.
I understand, but ma'am, there's nothing court can do about that. The two of you had that joint obligation. And as I stated, the court cannot intercede in that obligation between the creditor and basically the person that received the credit. So there's nothing that court can do other than what they've already done. And it's unfortunate, but there's no recourse at this point. Because as he said, he can't refinance it. So if he can't refinance it, then.
Which I do believe he would be able to refinance it due to his new financial status with his wife and all that, seeing how they are trying to already get another vehicle. So I believe that they would be able to.
Well, okay, I can't take anything into account concerning his new spouse because she wasn't a party to the divorce action. And so the court can't, it might be based upon her credit that they're getting the car. I don't know that. So again, unfortunately, there's nothing that the court can do in this matter other than what I've previously stated to you. So you can do an order, which, as again, would state that he's solely responsible for that and that you're not, and that he is responsible for repaying that solely by himself, and that you would be reimbursed for anything that they might have seized from the account to go towards that vehicle. But that's the extent of what the court can do. So I will let you prepare an order to that extent. You can submit it under a 7-day notice of entry, and that's all the court can do today. So you're free to go. Have a good day.
Station at Craig versus Ladero Edie.
Court will note the appearance of Ms. Reed on behalf of the defendant. This matter is before the court on the defendant's motion to show cause in this matter for violation of the orders of June 4, 2024 and August 9, 2024. In this case, I think Ms. Reed, pretty much your motion again lays out all of the action that you're alleging and just contesting in this matter. So what the court will do is the court will find the plaintiff to be in contempt of court She's not appeared. The notice stated that she had to appear in person. She's not appeared today. It is now 9:42 a.m. She was to appear by 9:30. And so the court will find her to be in contempt of court. In this matter, the court will issue as well a bench warrant because she has failed to appear. And the court will grant your request for additional attorney fees of $700. And the court had previously ordered back at the hearing on July 27, 2024, I'm sorry, 22, 2024, that she was ordered to pay $700 that she was supposed to pay that within 45 days. Apparently pursuant to the motion, she has not paid that. And she's also not set up the appointments with Meredith Katz, nor has she in fact exchanged paycheck stubs in this matter. So the court will find her in contempt for those reasons. And what happens, Ms. Reed, the court will grant you a writ of attachment / execution and or garnishment for the collection of those fees. And I'll ask, is there anything else, Ms. Reed, that we need to address today?
No.
Okay, that will do it. And if you will, Ms. Reed, prepare an order to that extent. You can submit under 7-day notice and we'll get that entered.
Just so you know, this case is over 360, almost 365 days old.
Okay. Court will note the appearance of Mr. Hilderly on behalf of the defendant. This matter is before the court on the defendant's motion for entry of a final order, referring the matter to the front of the court for calculation of child support. The defendant, excuse me, the plaintiff has not appeared. It is now 10:10 a.m. was set for 10 o'clock. Mr. Hilderly, I guess what I'd ask, obviously you can get your client's information from his income, is what is your thoughts as to the plaintiff's income? Are we imputing to her, do you know, or is she working or what?
I don't know the answer to that. Maybe my client would know, but I'm not even sure if he would know.
Okay, Mr. Daniel, do you know if she's working?
To my knowledge, I don't believe she is.
Okay. Why don't we do this, Mr. Hilderly? We can get this done real quick. Get your client's income, calculate. What we'll do is I'll allow you on the plaintiff to impute income of $15 per hour at 40 hours a week. So that's a gross of 600. And you can calculate it on that basis. And then you can do a uniform child support order. And I'll let you submit it under 7-day notice of entry, and we can get this done quicker than referring it to the front of the court. Anything else?
No, that will cover it, Your Honor. I will get that information and we will submit it with the updated calculations.
Okay, great. Okay, thank you. You're free to go. Have a good day.
The home in which the children were residing, my newborn son at that time and my 2-year-old daughter at that time, was very nasty. She admitted to asking her boyfriend, baby daddy, or to show up to the house and, in her terms, bring a sledgehammer to facilitate the actions that you saw on the video.
Since you've had the kids now for over a year, has the plaintiff provided any financial assistance to you to care for the children?